Well, why don't you begin, Aurelien, so we can all go home 3 minutes?
Yes, I'm going to start by discussing this topic of precautionary antitrust, where I started to think about how to understand what's going on in antitrust and this neo-Brandesian revolution. And I came with this idea that there's a very important aspect of the rule of law, and I think antitrust scholars sometimes just forget it. There's Lord Bingham who wrote about the rule of law, and it defined the rule of law as all person and authority within the state, whether public or private, that should be bound by and entitled to the benefit of laws public and prospectively promulgated and public administrated in the courts. So the key aspect of this rule of law is the separation of power and also the independence and the role of the judiciary, but also the right to a fair trial. So my presentation's gonna ask and try to answer, do antitrust reforms better protect the rule of law? So first, I'm gonna quickly discuss the rule of law in antitrust, and second, I will tell you how much precautionary antitrust is undermining the rule of law, how precautionary antitrust is harming consumers and innovation, and finally, why do we need a dynamic antitrust whereby there's an evolutionary aspect in antitrust enforcement. So what is the precautionary antitrust? Well, that comes from the idea that the precautionary principles entered antitrust policy and antitrust enforcement. So as you can see, precautionary principle motto is we are better safe than sorry. So we just have to intervene and to regulate just in case something bad is happening. So by encapsulating the precautionary principle, I think that antitrust enforcement has departed from its concerns for innovation. So what is the precautionary principle? Well, very quickly, we have key documents. For example, the United Nations of this conference of Rio in 1992 defined the precautionary principle as where there are possibilities of large or irreversible serious effect, scientific uncertainty should not prevent protective action from being taken. And we have the same in European legislation. So what does it mean is that even though we don't know, even though there is a huge uncertainty, well, this uncertainty justifies interventions, justifies regulations. Because we don't know, we need to regulate, right? It's not because we know, but the unknown risks, the unknown consequences will justify preemptive regulations. In the US, there's a much more skeptical approach to precautionary principle, where precisely in the Benzen case, the US Supreme Court early in 1980 said that the agencies cannot rely on mere conjecture of risks. So you need to have a real likelihood of harm in order to intervene. This precautionary principle is at the heart of the European approach. In 1999, you have the Trade Commissioner of the European Union, Pascal Lamy, who later became the head of the World Trade Organization. He said, in the US, they believe that if no risks have been proven about a product, it should be allowed. In the EU, it is believed that something should not be authorized if there is a chance of risk. So you see this reversed burden of proof, like we don't know, but we stop or we prohibit it because we don't know unless the entrepreneur or the firm has proven otherwise, right? So it's all about risks. It's not a risk assessment as we know it. It's a different type of risk assessment where the lack of risks is precisely justifying the interventions. So the question was, when it comes to antitrust, is what about the competition risks? If we apply this notion of environmental regulation to competition risks, is there an emerging concern for competition risks about the market structure? Well, we can recap the precautionary principle according to key elements. So first, you need uncertainties, right? Second, you need hypothetical risks, not just likelihood of risks. Then, because of these risks, you shift to ex-ante interventions and no longer with ex-post judicial enforcement. And also, you have a reversed burden of proof and you need to have irreparable harm, meaning that if you don't intervene, then the situation will have tipped, will have just reached positions where you cannot reverse back to the positions as it was before. And all this is a dramatic shift from a liability system to regulatory compliance system. So when it comes to Europe, there's one key illustration of this precautionary antitrust, and that's the Digital Market Act, right? The piece of legislation that is about to come into force in Europe. Well, I just put a question here. It was a question from a member of the European Parliament asking Margaret Vestager, who was in charge of the competition policy, asking her if we could apply precautionary measures in antitrust case. Like, why can't we intervene ex ante rather than adjudicating and prosecuting firms, and these prosecutions will last many years? And Vestager's response was that, yes, we would apply precautionary measures in antitrust. This was in 2017. 2 years after, they proposed, they started to think about the DMA, what was called before these new competition tools. And this new competition tool and the DMA is basically justified, I mean, explicitly in the preparatory documents, is basically justified on two sets of risks. First, structural risks to competition. And second, the risks on the structure of competition. So you see that the question is not so much about anti-competitive conduct or abuse of dominant position, it's about the risks to the market structure, basically. And then you see a fundamental change from the rhetoric of choice over harm. You no longer look for consumer harm in order to evidence anti-competitive conduct, but you just want to increase the consumer choice. And of course, consumer choice refer to the market structure, to the number of companies present in a market. And also, there is a reversed burden of proof, right? So regulating a small set of companies, the so-called gatekeepers, well, you apply a reverse burden of proof, which is inherent to the precautionary principle. Remember, just prohibiting or banning unless the company or the entrepreneur show otherwise. And finally, it's not so much about antitrust liability. I mean, both European enforcers, but also American enforcers say that they were tired with prosecuting companies, and they were tired of bringing case. What they want is compliance, regulatory compliance. So there's no harm to be demonstrated. It's more compliance. So, for example, all this rhetoric of the precautionary principle, this language at least, you can see it embedded in the Digital Market Act. For example, the Restore 26 of the Digital Market Act, where they describe the situation of gatekeeping, say in such a situation, it appears appropriate to intervene before the market tips irreversibly, right? So this concept of irreversible of harm, right? So if you don't do anything, it would be irreversible. Just to come back to earlier what we said, it looks like there is an antitrust emergency. Vestager in 2020 precisely said that the Digital Market Act, the new competition tool, this is part of our toolkit that we had not used for some time, but it allows us to stop behavior that is likely to result in a serious and irreparable harm to competition, provided that we can prove that a prima facie infringement of competition rules is ongoing. So the concept here is a serious and irreparable harm to competition. That is the concept that is underpinning the precautionary principle in other areas of law. So the notion is that ex-ante regulations can overcome the issue that litigation is too slow and, of course, uncertain. So with regulatory compliance, of course, you'll have the governments that always win because you don't bring a case and there's no uncertainty of losing a case, just to paraphrase Justice Stewart. What about now American precautionary principle, right? So we see that there is a fundamental development of the precautionary antitrust in Europe with at least the Digital Market Act, where the rhetoric is borrowing from the precautionary principle. What about in the US? Well, first you see those antitrust bills. These antitrust bills lay down the do's and don'ts, the rules, the prohibitions, the obligations in legislation, so that companies will be prevented or mandated to do something. This is to avoid litigation, of course. Last time we had that in 1914 with the Clinton Act, or 1937 with the Robinson Patent Act. So this idea of just making in written the obligations and prohibitions in terms of antitrust behavior, rather than the courts discovering what is anti-competitive and what is pro-competitive. But let's assume that these antitrust bills are very unlikely, are quite perhaps unlikely to pass in Congress. We don't know, we'll see. But at least the DMA in Europe is for sure going to pass. So absent those antitrust reforms in Congress, where we started to see that the FTC is very much interested in engaging in rulemaking when it comes to unfair method of competition. So this rulemaking authority of the FTC is justified equally by the necessary shift from ex post to ex ante rules of competition. So let me say why I think that the FTC rulemaking authority, when it comes to unfair method of competition, is very likely to be illegal under the current rules, and certainly harmful economically. So the precautionary antitrust in the US is mainly embodied by the FTC using this very arcane Section 6G of the Federal Trade Commission Act. And the idea is to use that Section 6 as a legal basis in order to shift from ex post to ex ante rules of competition. First, before looking at this Section 6 of the FTC Act, it's very important to see that, well, innovation is dynamic efficiency. But remember that neo-Brandesians mostly are against the efficiency or the efficiency defense, right? But in antitrust, you have this rule of reason that balance out pro-competitive and anti-competitive effect. And that's why they are against this rule of reason that courts have allowed and the judicial balancing has enabled, right? So the question for them is to revert back to per se rules of illegality, right? The very concept of a rule of reason where you go before the courts and you justify through efficiency or inefficiency your behavior, then that's, for them, it's a wasted time and it's too complicated. So that's why they want to revert back to per se rules of illegality. And that was at the heart of why the FTC has rescinded its 2015 statement on Section 5. It was an attack on the rule of reason and the very balancing exercise, where the statement of the FTC said that importing the rule of reason's likelihood requirement will abrogate the Commission's statutory mandate to combat incipient wrongdoing before it becomes likely to harm consumers or competition. Tying Section 5 back to this framework of the rule of reason offends the plain text, structure, and legislative history of the Section 5. So you see that the question is to prohibit incipient wrongdoing, right? Before they arise or before they really materialize in terms of harm, the incipiency doctrine will be used by the FTC in order to intervene ex ante and to prohibit those practices. So this, I think, is very much against innovation and the evolutionary process of the common law that is disparate. I mean, there was a report from the Roosevelt Institute titled "Taking Antitrust Away from the Courts," right? So it's pretty clear what the objective is to take antitrust away from the court in order for agencies to regulate it and to enforce them quite clearly. So the FTC's 2020 regulatory priorities say that very clearly. I mean, the case against courts say that the case-by-case approach to promoting competition, while necessary, has proven insufficient, leaving behind a hyper-concentrated economy whose harm to American workers, consumers, and small businesses demand new approaches. And this approach is, of course, not a judicial judge-made law or judicial process, but it's a kind of precautionary approach to competition. And so what I believe is that the evolutionary economics, so how the evolutionary process of the courts pretty well fit with the notion of evolutionary economics and the emergence of behaviors that may be pro-competitive or anti-competitive, but also that judge can tell them apart with better knowledge rather than the enforcers prohibiting them ex ante. So at least the FTC made it clear that for 2022, so this year, the FTC will consider developing both unfair method of competition rulemaking as well as rulemaking to define with specificity unfair or deceptive act or practices. So now let me go straight to the point of the American precautionary antitrust when it comes to Section 5. So I think the FTC rulemaking when it comes to unfair method of competition is probably illegal. We'll see what the courts say, but I think it's very likely to be illegal. So Section 5 said that unfair method of competition in commerce are hereby declared unlawful. It's very short, very general. Section 6G of the same act said that the FTC has the power to, quote, time to time classify corporations and make rules and regulations for the purpose of carrying out the provision of this chapter. The main question is, what does this mean? Does it mean that the FTC can enact rules and regulations, substantive rules and regulations for unfair methods of competition? Or does it mean that it's just interpretive rules or organizational rule? Well, I looked at the legislative history precisely because Chair Khan said that this will violate the legislative history. And the main proponent of the FTC Act was President Wilson, who precisely on January 20, 1914, delivered a message to Congress in order to justify and to push for the creation of the FTC. He said that the opinion of the country will instantly approve of such commission. We will not wish to see it empowered to make terms with monopoly or in any sort to assume control of business, as if the government made itself responsible. It demands such a commission only as an indispensable instrument of information and publicity, as a clearinghouse for the fact by which both public mind and the managers of great business undertakings should be guided. What does it mean? It means that it's a help for the government already. That's the help of the antitrust division in the DOJ. But the FTC was mostly perceived as a clearinghouse in order to provide information and publicity in order to identify this potential anti-competitive conduct. But it wasn't seen as a rule-making body, as making rules, right? It was more seen as assistant, as helping the antitrust divisions by its expertise. And during the debate of the passing of the FTC Act, at the very end of those debates, just to tell you that how unclear those unfair methods of competition were, Senator Sutherland asked, what are unfair methods of competition? Can anybody tell me? So it wasn't clear. And he then suggested that UMCs are an attempt upon the part of one person or corporation to impose by his or his goods or businesses upon the public as the goods of a business of another one. Well, that's what lawyers would call misrepresentations or confusions. That would better be classified as unfair act of practices, as a violation of consumer protection laws, rather than unfair method of competition. So we don't really know what unfair method of competition is, because most of the time it's confused with unfair act and practices, which belongs to consumer protection. So the first case that was decided by the Supreme Court in order to define what is unfair method of competition is the case FTC versus Gratz from 1920. And the court very unequivocally said it is for the courts, not the commission, ultimately to determine what the matter, sorry, as a matter of law, what unfair method of competition includes. So at least the Supreme Court was very clear in saying that unfair method of competitions need to be defined by the courts, not by the FTC. Then you have the very famous case of National Petroleum Refineries Associations in 1973, where you have a DC Circuit who found that Section 6G granted FTC the regulatory power to engage in unfair method of competition. So you will say that, well, that's clear cut and the debate is over. But the issue is that 2 years after, because of the unhappiness of Congress, Congress has passed the Magnuson Moss Warranty and FTC Improvement Act, which explicitly authorized and mandates the FTC to do rulemaking when it comes to consumer protection, but explicitly exclude the ability for the FTC to do rulemaking when it comes to unfair method of competition. So it is very puzzling that now we can have some arguments saying that there is a case for unfair method of competition for the FTC, whereas the Congress has never mandated the FTC to do so. So also the arguments that we should have rulemaking because it's much quicker to prohibit, to do the do's and don'ts of the game, so that it would be easier than adjudications. Well, under the Magnuson-Moss Warranty Act, the average time for a rule to be adopted is 6 years. So this just at least tell you that the adoption of any rule under that act is very lengthy, it's very cumbersome, and it's very long, right? So that's why it's very clear to say that Congress didn't mandate the FTC to engage in rulemaking when it comes to unfair method of competition. And because there is no implied power when it comes to agencies, you need explicit power, right? It's hard to imply a power for the FTC to engage in unfair method of competition. But let's assume that the FTC wants to engage in unfair method of competition. Well, I think it would certainly be harmful to the economy and to innovation because it would resemble this type of precautionary approach. So the FTC said precisely that it should engage in unfair method of competition because of the executive order issued by President Biden. So it said the recent executive order encouraged the Commission to consider competition rulemakings related to non-compete clause, surveillance, right to repair, pay for delay pharmaceutical agreements, unfair competition in online marketplaces, occupational licensing, real estate listing and brokerage, and industry-specific practices that substantially inhibit competition. So that's quite a large mandate from the executive order, and that is right. But all these practices that the FTC could end up being prohibiting or banning, well, there's a large expectation that these practices may have pro-competitive effect. And that's why we need the balancing argument between pro-competitive and anti-competitive effect of these rules. But that's exactly not the point of rulemaking. The point of rulemaking is to have per se rules of illegality. But since the court cannot go back to these per se rules of illegality, then the FTC may try to have this effect through precautionary regulation. So when it comes to rulemaking, the FTC has made a solicitation for public comment in August 2021. And the two solicitations that the FTC cited are two petitions from Open Market Institute, and they refer to non-compete clause and exclusionary contract. Julie talked about the non-compete clause, but I will very quickly talk to that. So the non-compete clause. So first of all, you can see that the states are very different positions when it comes to non-compete clause. The red state here prohibit non-compete clause, whereas the green state just allow non-compete clause. So the main question is that a federal power? Should the federal government regulate non-compete clause, or should it remain at the state level? Second of all, there's only 8% of employees that are unaware of having signed the non-compete clause, meaning that most of them willingly sign non-compete clause. And also, the common law has traditionally prohibited unreasonableness of non-compete clause. That goes back to English law in a very famous case of 1414, the case of John Dyer, where a dyer was prohibited to open up a new hairdresser shop within a geographical area. And that was deemed to be unreasonable by the courts. So the question is, rulemaking in non-compete clause, either it just prohibits unreasonable non-compete clause, and that's already the law, right? Or it prohibits all non-compete clause, reasonable or unreasonable, like in a precautionary approach, like just a total ban, irrespectively of the pro-competitive effect. And that will have, of course, major innovation harm, right? Because we know that non-compete clause are a way for employers to invest in human capital. So either way, it's very likely that the prohibition of non-compete clause, irrespectively of the reasonableness of non-compete clause, may have unintended consequences. Very quickly, I talk about the exclusionary contract, where again, the FTC may engage in prohibiting exclusionary contract de facto, like with some sort of per se illegality. But it's very well known that exclusionary contracts have some pro-competitive effect, and only unreasonable exclusionary contract should be prohibited. So very quickly, just to conclude on antitrust via rulemaking and the shift to a precautionary antitrust. So even the criticism, or at least skepticism of rulemaking, came from sometimes proponents of the new administrations. For example, Tim Wu wrote some years ago that a poorly designed regime may both fail to create additional competition and, worse, serve to insulate the industry from antitrust scrutiny. What he meant by that is that when you regulate an industry through competition, well, you just have that these actors in that industry just have to comply with the regulation, and therefore there cannot be a legitimate case in antitrust to be brought, because regulatory compliance show the absence of abuse. So there's a real trade-off between adjudication and regulations. If you regulate, then the room for adjudication is much reduced, and that will perhaps also create some sort of antitrust immunity, because as long as those companies comply with the regulations, there will be no case to bring, right? So this is something also to have in mind. So just to conclude on the need for dynamic antitrust, precautionary antitrust is very much a static view of competition, where you prohibit ex ante rather than letting the market to thrive and emerge, so that you can depart and single out anti-competitive conduct. Also, precautionary antitrust is applied to the most innovative sectors of the economy and to the most innovative companies. So the precautionary antitrust is mainly a shift from ex post to ex ante rules of competition. It undermines the courts because litigation is seen as a burden, as a cost, and they lay down a set of rigid rules which are not adaptable to changes. So the precautionary antitrust also ignore the evolutionary process, or what I call the efficiency process of the common law. And this adds back to Justice Holmes, the common law in 1891, or just Judge Posner or George Priest. I mean, the efficiency of the judge-made law has been widely discussed, and the inefficiency of very rigid ex ante rules cannot be ignored. So finally, we need dynamic antitrust. What is dynamic antitrust? I will say it's both a dynamic enforcement, so the evolutionary process of antitrust law is better captured by a court system, by an ex post antitrust liability, where the rule of reason, where the consumer welfare standards are set to better protect the rule of law, because it would better protect the legal predictability of those enforcements, and also better avoid innovation cost. And dynamic antitrust also mean dynamic competition, this process of evolutionary economics, where it is fully embedded in the evolutionary, in the economic analysis of law, where dynamic competition matters more than static competition, where disruptive innovation matters more than just marginal price competition. So the conclusion is that precautionary antitrust is less likely to adhere to rule of law principles because of its ignorance of the court system, and are more likely to stifle innovation. On the contrary, dynamic antitrust is more likely to promote dynamic competition and less likely to undermine evolutionary process of the court. Thank you. Yes, I'm
going to have the last word because we're running out of time. And I'm going to make one observation and then one thank you. The observation is what you said about the ability of an antitrust decree to insulate people from judicial attack also applies in the environmental area. So what many companies who are big polluters do is they enter into long-term agreements with the EPA to slowly reduce their pollution and use them as a defense against common law nuisance actions, which would be much more effective. Okay, that's the observation. The actual principle is this has been a very long day. And so since Aurelien cannot bring himself to, since he said all the welcomes, what I will do is bring myself to say all the thank yous. I don't even know where the views are anymore, but I think it's the case that only the hardy have survived. Fortunately, this is on take. And what I'd like to do is to thank all of the survivors who have stayed this particular long. And as ever, just as the time when we're all about to part, I'd like to thank all of our friends and enemies and everybody else for coming and for doing the kind of work that we have here. I think you've deserved a well-earned rest, and I hope that we will spread this tape far and wide because I think it does contain some very instructive debates about the way in which this thing works. And this is clearly of utmost urgency given the very proactive activities in the DOJ and the FTA today. So thank you all for coming.